Mr Johnston.
My ladies, my lord. I should start with an apology, which is that when identifying counsel this morning, I did not identify Ms Cranmore, who appears in relation to the Redevco appeal. So my apologies to her and to the court.
And my apologies to you also, that I didn't say. And Ms Cranmore.
Before the short adjournment, the court asked me a question about the EU authorities in relation to deferral. The picture is a little more complicated than what one might think. And I've spoken to Mr Margolin. He's very happy for me to spend a little bit of time overnight and come back to you in just 5 minutes tomorrow. The picture includes the fact that deferral is in fact one of the options under Section 3Z, Schedule 3ZB that applies to his client. I just want to make sure that I've got the full picture in that respect. There was also a question about the relationship between Section 2 and the Human Rights Act, which I think I'd addressed actually in submissions this morning. I was just addressing you in relation to the judgment, and I was nearly through with doing that. You have my submission in relation to paragraph 146 and how it gets read with paragraph 150. Paragraph 147, rather, having adopted a conforming interpretation that provides for payments over 5 years, UK law now conforms with EU law. There is therefore no need and no ability on our part to introduce a further provision to allow for acceleration of payments in the event of a disposal of the assets before the end of the 5-year period. And you have my submission on that in relation to choosing. Paragraph 148 deals with the question of payment in intervals. And one of the things that it says is, or it identifies, is that there is a provision in UK law that allowed for payment of CGT in instalments annually. That's section 281 of TCGA. I'm going to return to this more fully later. Just to put a marker down now, that is a provision that has nothing to do with trusts and nothing to do with exiting the jurisdiction and nothing to do with EU law. But I will come back and make that submission more fully later when it arises at the relevant point. Paragraph 152 deals with Fleming. I've already taken you to 150. Fleming, nor do we consider that the decision of the Supreme Court in Fleming is relevant to these appeals. And then it explains that in Fleming, the UK retrospectively removed the right of taxpayers to make claims without any transitional period. The courts found that the taxpayers had a right to be told in advance that their rights were going to be restricted and that they had to be a sufficient transitional period. These circumstances are in complete contrast to the circumstances in these appeals. The exit tax levied by the UK is compatible with the appellant's EU law freedom of establishment. Now, just pausing there, this is the point that I took you to earlier in paragraph 130, subpara 1. That is not right. The exit tax levied by the UK interferes with the appellant's EU law freedom of establishment, and as it was in the legislation at the time at least, was not compatible. Now, it may be that the right way to read it is the exit tax levied by the UK as read pursuant to the conforming interpretation that I have just given. And if that's the case, then that's certainly, let me put this way, very compressed. The mischief lies in the failure of UK law to give the appellants a right to defer. You have heard me on that already. The proper way to think about it is that there is interference and that there must be a right to choose. The conforming interpretation that we propose has the effect of improving the position of the appellants. And so what seems to be the concern here is that there should be no option that is too generous to the appellants maybe, or that what's happened in the case is to improve the appellant's position. We do say, with respect, that that is not right, because it follows from the wrong starting point. The starting point being not, as the Upper Tribunal seems to have thought, that exit taxes don't necessarily interfere with the EU law freedom of establishment at all, and in particular, once we've produced a conforming interpretation, that they don't. We say that the conforming interpretation that's proposed in this case, of course, does not improve the position of the appellants. What it does, many, many years after they left the jurisdiction, is find a scheme which is akin to that produced by Parliament and drop it into the legislative regime, and then hypothesise that they were offered a choice that was never a choice in the real world. The last the point to touch on, really, I think, is in paragraph 158.
Well, I'm so sorry. Does the Upper Tribunal, does this idea of choice feature in the Upper Tribunal's reasoning?
The question of choice.
Yeah.
So it's dealt with at paragraphs 146 and 7,
Right.
where they say it is open to us to make choices provided they're not of a type that require deliberation.
No, but you're talking about choice open to the taxpayers, and my question is, does this important feature of your submissions feature in the reasoning of the Upper Tribunal?
Sorry, my lady, it may do in paragraph... No, I understand entirely the question. It may do in paragraph 158, which was the paragraph I was just taking you to at that point. The retrospective nature of the conforming interpretation is also an answer to Mr. Johnson's submission that a conforming interpretation doesn't vindicate the trustees' EU law rights, as it's now too late for them to be able to exercise any option that the conforming interpretation may have given them. So this is the point where the court grapples with that point.
Yeah.
This is not a case where conforming interpretation gives rise to a retrospective imposition of a tax liability. I'm not sure I squarely accept that. I think this is a case in which the starting point is that there is no lawful tax liability, and it does do so. The conforming interpretation gives retrospective effect to a relief from taxation, namely a right to pay the tax in instalments. Mr. Johnston is, in a sense, looking down the wrong end of the telescope. And this was the point I made to you earlier, which is that with respect, the Upper Tribunal and its finding that I was looking down the wrong end of the telescope follows, in my respectful submission, from the flawed starting point. And then if you read down into the paragraph, as that interpretation has retrospective effect, the right to elect to defer a payment was always available to the trustees. Now that's right in the very abstract sense that the declaratory nature of conforming interpretation gives rise to that result, but you've heard my submission on the fact that there are different kinds of retrospective effect in relation to conforming interpretation, and the unusual feature of this case lies in the choosing, and that's not something, in my respectful submission, that the Upper Tribunal has adequately dealt with. The fact that the trustees might not have been aware at the relevant time that they had the right to elect to defer payment, again, the fact that the trustees might not have been able at the relevant time to exercise a right to choose, I would say, and then they say, is irrelevant. And we say, with the greatest possible respect, it's not irrelevant.
Will you take us back to Lord Newburger? I'm sorry.
Sorry, no, after you.
No, and you would take us back to what Lord Newburger said.
Precisely so, in relation to the hypothetical nature of such an option. And that's why we do say that the retrospectivity point can't be simply knocked aside by saying, well, all cases are retrospective and that's fine. We accept that point squarely. We just say that there are particular features to this case. And then the final point...
No, I'm sorry, because I interrupted my lady.
Of course,
no, it's fine. It doesn't matter. I've thought better of what I was going to ask.
I'm not sure that's a good thing or a bad thing, but I'll plough on. So that then leads me to
I'm not sure either.
to my last submission on the judgment, which is that, in my respectful submission, it doesn't adequately deal. It records a submission, I think it's in paragraph 127. No, it's not 127, it's somewhere else. I'll find it in a moment. It records the submission that this is the interpolation of a scheme. And that's the primary submission that I've made before you today. It was the primary submission I made before the Upper Tribunal. But it doesn't grapple with the point. And let me just put down the mark on it now. I'm going to come on to this in relation to ground 1, but just to develop it. Each of the different tests, if I can put it that way, for the threshold between interpretation and amendment or legislation are freestanding in my submission. So if you're with me that this is illegitimate because it is the interpolation of a scheme, then I don't have to persuade you that furthermore it was a scheme that involved the making of choices. And I don't have to persuade you that furthermore it had a retrospective effect that was, in this particular case, of a kind that offended against the principle of legal certainty and in particular the EU law right of my client to choose. So just to make clear that those are, they're not a sort of, they're not a combination of factors in respect of which I say I need to persuade you in respect of each of them. Quite the contrary. They are different tests. And if we fall foul of one of those tests in this case, in my submission, that is enough for this appeal to be allowed. So that's what I have to say about the judgment. That leads me on to my grounds. And with everything that I've said, I hope I can be relatively brief on my grounds of appeal. So starting with ground one, which is, as you know, very simply, that there is no lawful conforming interpretation in this case of the kind found by the Upper Tribunal, because the conforming interpretation found by the Upper Tribunal strays beyond interpretation and into legislation. And it is, in that sense, the court stepping beyond the bounds imposed on it. And the first reason for that is for the reason I've already articulated to you to some extent, and as I took you through the case law, I hope made good, which is that it involved the making of a new statutory scheme. And that is the Rubicon that must not be crossed. That's why the starring scheme in Re S was rejected. That's why the new transitional, part of the reason why, the new transitional provisions were not to be read into Fleming. And we do say that that is precisely what has happened in this case. What we have in paragraph 141 is a scheme. It is a scheme that mirrors very closely, albeit more compressed, Schedule 3ZAA of the Taxes Management Act. I won't turn back to it and take you through it, but what we have here, as in 3ZAA, is a gateway provision. So you have to be a party whose, where the taxpayer's right of freedom of establishment would otherwise be infringed. You then have the mechanism in 141. I took you through it earlier. You have to have an option to defer. That option to defer has to be in 5 equal instalments. There is a provision about when the first instalment is payable, normal due dates for payment, and yearly intervals thereafter. And as you know, the Upper Tribunal also went on to deal with interest.
Was it 6 instalments
under the statutory scheme? Yeah. It's 1 plus 5. Here it's 5.
So this is not the same.
This is, in that respect, this is the sole respect in which it's.
This argument is based on this kind of concept of a scheme, as if that's something that's almost a term of art. There's no sort of definition in the case law of a scheme, and it rather suggests to me that it's sort of a matter of degree. That yes, you're trying to bring in something which is complex, which might have lots of ramifications and so on. Some people might call that a scheme, a statutory scheme. Mm. Other things might be considered fairly simple and straightforward, including arguably an option to pay something over 5 years rather than 1.
But, my lord, I squarely accept that there is no precise definition of the boundary between a scheme and a change. Let me put it that way. And in that sense, that's a question for the court to consider, taking into account all the factors. I can't say there are 4 hallmarks of a scheme, and because of the 4 hallmarks of a scheme are all satisfied, I'm in scheme world. What I do say is that this is a case where the word scheme is perfectly apt. And the reason for that is it is not just the reading in of 1 or 2 words, the reading down of 1 or 2 words. It's not like Gaidán and Godin Mendoza, where the question was whether or not we could expand the definition of a partner, effectively. What is being done here is we are having to have a gateway provision for who accesses this. Then we have a structure for payment, and embedded within this, as I say, must be provision as well, albeit not articulated in relation to how the penalty rules are going to apply. Now, it's very difficult, in my respectful submission, to imagine how that could be anything other than a scheme. When drafted out in full, in a very, very similar, not identical fashion, and I recognise there are bells and whistles in Schedule 3ZAA that don't need to be done for the purposes of conforming interpretation, and the form of drafting is different. I accept all of those points against me. But it would be very difficult not to describe Schedule 3ZAA as a scheme for payment, exit charge payment plans. And in those circumstances, I say this has all of the hallmarks of a scheme. And it does not have the hallmarks of a gloss or a different reading to be imposed on certain words, or and even, you know, in the expansive example, and we know you've seen examples where the court has refused to provide a conforming interpretation of this kind, but taking Vodafone 2, what you have is a structure. You have the scheme already carving out, in that case, a long list of exceptions. We add in one more exception, which is a single one-line additional exception in the context of the entire framework of the Act. Here we really do have something that's rather different, in my respectful submission. It requires quite some detail and quite some drafting to get your head around. And so I don't pretend that that I can draw a precise line between schemes and changes. But I do say, in my respectful submission, that this is rather a long way over that line. And you've seen some of the cases where the courts have declined to make changes that are, in some cases, less substantial than these. An ample award would be a good example of that. We do also pray in aid here what Lord Justice Lewison said in ample award. I've made this submission before, so I won't repeat it in any great length. But Parliament and the Upper Tribunal agrees, I think, that 3ZAA is a scheme. It certainly says it involves the making of choices. In that case, Lord Justice Lewison was persuaded by the fact that Parliament had subsequently, in light of the development of EU case law, made amendments and not given them retrospective effect, have made a scheme and not read it backwards. And we do say that in those circumstances where we know, if we're asking the question, what did Parliament intend in 2019, we know the answer is not this. Because they could have done, and it's something specifically that Lord Justice Lewison relied on in that case. The second feature of this submission, the second limb of this submission, is the one I've addressed you on at some length already. I won't go over all the ground again, but this involved the choosing between different policy options. And I do say it's not straightforward how one reconciles paragraph 146 and 150, because it is quite clear that if making 3ZAA involved the making of choices, that the making of paragraph 141 involves, in my respectful submission, the making of choices. And you've heard my submissions already in relation to the best fit tool, which was the methodology by which the court circumvented, if I can put it that way, or the tribunal circumvented that problem. And you've also heard my submission that I simply don't accept, and I don't think the proposition has been made good, that there is a best fit. And certainly the Upper Tribunal hasn't established that within its own reasoning, and therefore that methodology, in my respectful submission, simply doesn't help. And as regards the going beyond point, the same point stands, which is it's just not established that 5 equal instalments does not, would go less far than deferral until realisation. The third limb, and as I emphasised earlier, each of these limbs, each of these tests is, in my respectful submission, a sufficient basis to find that this steps over the threshold into legislation. Third, it offends against the principle of legal certainty. You've heard me on that. I won't take you back to Lord Scott in Fleming, but you've seen what he says on that in that particular case. And the point there, in my respectful submission, is a powerful one, and it's one that bites here because of the form that it takes. The form of the retrospectivity in this case is unusual, perhaps, and it is very closely akin to the reasoning we say of Lord Neuberger in paragraph 85. In that case that I've already shown you, you can make legislation that conforms to EU law by reading a new scheme into the Act, but that only generates a hypothetical right to choose. And as Lord Neuberger put it, a reasonably well-advised person has to be in a position to take advantage of that choice. And just pausing here, you have seen the evolution of HMRC's case. It's not until nearly 15 years after my client departed that they first suggested that payment in instalments might have been lawful. And had my clients asked for that at the relevant time, the answer would have been absolutely not. Now, there seem to be two answers in the judgment to this point. And the first, we've already looked at briefly, is in paragraph 157, which is that my clients always had the right to defer payment of the tax. And we do say, sorry, I've highlighted it in my version, doubtless you haven't. It's in the third line, second sentence, because the conforming interpretation has retrospective effect. The appellants always had the right to defer payment of the exit tax. And you have my submission about why that is not an adequate answer in this case, because it's the choice that is the touchstone of my client's rights and my client's entitlements. And then I've already addressed you in paragraph 158 on the finding that the fact the trustees might not have been aware at the relevant time is irrelevant. And we say again that it is relevant because a hypothetical entitlement is no entitlement at all. And then the final answer from my learned friend, and to some extent the Upper Tribunal, seems to be to say, well, look, the Panayi trustees have had a sort of form of benefit of deferral anyway. And that's because they've challenged the lawfulness of the statutory regime. And so they haven't paid. This is the point my ladyship was making right at the start, clarifying the factual position. And so therefore, this is all a storm in a teacup. How can the Panayi appellants complain that they should have had a chance to choose to defer? Actually, what they've done is they've challenged by way of an appeal, and we're a very long way past, and they still haven't paid, and therefore they have had the benefit of deferral in that sense. We do say with respect that's a wholly unrealistic way to present and to think about and to assess the facts of this case. My client has not had the benefit of a choice to defer in 2004. It has had to challenge as unlawful the statutory scheme applicable to it. It has had to go to the Court of Justice and win. And the unreality of the argument is clear from the logic that underpins it. So there's a hypothetical option in 2004 and a hypothetical choice. And the argument seems to be that we can read back into the past a decision on the part of the trustees to exercise their right to defer, and further a decision on the part of HMRC to agree to that. Because as we know from having seen the statutory regime, just the option to defer is not enough. There's an agreement that needs to be entered into in that respect, in the exercise of their discretion, and that matters therefore should proceed on the basis that we are in that wholly hypothetical world. We read back into the past the existence of an agreement on the terms of the exit charge scheme and on the waiver of the obligation to pay penalties, and that is the basis now on which tax should be paid. And we do say, in my respectful submission, that that is a wholly unrealistic way of approaching this case. And it offends against, firstly, my client's right at the point of exit to have a choice, and secondly, it grants them that choice in only a wholly abstracted and unrealistic manner. Fourthly, sorry,
just pausing there.
Yes.
Sorry to interrupt again, Mr. Johnson.
Not at all, my lady, I'm grateful.
But isn't there a lack of reality in your submission, which is that it is difficult. I mean, this is the point I put to you right at the beginning. It's extremely difficult to see any circumstances in which a body of trustees faced with the choice of immediate payment of the whole lot wouldn't opt to defer. So it's a hypothetical choice in a different way.
Well, I'm not sure that the court can proceed on a sort of judicial notice that any trustee would choose.
Judicial notice, it's just
so or common sense. Well, I mean, I think that would depend on the financial circumstances of the case. So in this particular case, my client's intention actually was to sell, and you can read this in Mr. Panayi's witness statement, their intention was to sell the assets almost immediately, and that took rather longer, and that's why it ended up being in December 2005. It's perfectly possible that they might say, actually, no, we want to regularise our financial affairs, we don't want to be paying tax in the United Kingdom in 4 years' time, we don't like the interest rates at which we're going to be paying tax in the United Kingdom. There's a whole series of commercial decisions that would need to be made. So I recognise the sort of, I recognise the origin of the question, but I do say that it presumes a choice, an agreement, and an outcome which are not automatic. And I also say that what it does is it puts my client in a position where, having not had a choice, they are told 22 years later that they took a choice. And that is a surprising position, at least for the court to find itself in. And the court should be cautious. We are straining, in my respectful submission, right at the edges of the boundary of what the court should do. Not only are we finding a conforming interpretation which is a pretty detailed scheme and dropping it into the legislation, then we're presuming the hypothetical outcome of an exchange between my client and the revenue.
Why is that necessary? The conforming interpretation just says that you have to be given the option to defer. It doesn't, and that must mean without the revenue agreeing. They've got to give you the option.
Well, so there's two options.
So
one is
about the agreement, I'd suggest.
Well, one is that there are two scenarios here. One is the answer is, well, my client had an option to defer, but it was foolish and it never exercised it, and therefore it can't.
Well, it didn't know about it.
Well, but they didn't know about it in any circumstance model. But there are only two routes through the analysis, I think. One is to say, pursuant to the conforming interpretation, we retrospectively identify that you did have a choice at the time, and you didn't exercise it, and therefore all of the tax is payable from the point of departure. That's option one, because you had the choice. It's irrelevant that you didn't know that you had the choice. The other option is to say, we are going to, by conforming interpretation, say that you had a choice, and we are going to presume that you exercised that option, albeit, as I say, under the statutory regime, it is an option that must form a part of an agreement. We're going to presume that you did, and we're going to proceed on that.
There isn't any need for the second step. The question is, what does the statute mean?
Yes.
But I mean, it does seem somewhat unreal, this argument, because the reason why the choice has, if one postulates a choice, has become, as it were, hypothetical, is just because more time has passed than the end of the 5 years. And the consequence is that you've had more than 5 years to pay. So it seems a very odd thing to be complaining about, as it were, saying, I wish I'd had this choice, when you've actually had longer than the option would have given you.
So my lord, I think the answer...
In practice.
So the answer to that is in multiple parts. The first part of it is to say that the complaint, if I can put it that way, as it's described, is that the law was unlawful at the time of exit. And so the choice wasn't up to the end of, just to clarify one point in your question to me, the suggestion that we might have had a choice for 5 years. No, there would only ever be a choice at the point of departing. There would be a momentary choice at that point, but that's a relatively minor...
Well, depending on what the law was.
Well, but then, my lord, that's where we find ourselves in an even more... We're back
I know, but you're then pushing back against that and saying, well, you can't end up with that result because, as a matter of fact, we can no longer have that choice. And what I'm suggesting is that that's just, as it were, a consequence of the passage of time, because the choice is about deferring over a length of time.
Yes. And so that's why we say this is an unusual case as regards retrospectivity. Retrospectivity applies differently in this context, in the same way that it was hypothetical in Fleming and therefore not something that the court would read in. In this case, the granting of a hypothetical right that could not be exercised at the relevant time is, we say, something that offends against my client's EU law rights, the right of freedom of establishment and the right to make a choice at the relevant time, my lord.
If a thought experiment, supposing that there could have been, everything could have been accelerated, so that there was, as it were, an instantaneous decision at about the time, you were seeking a declaration
Yes.
or something, at about the time of your exit. And do you say in those circumstances, if a conforming interpretation of the kind that had been was given at that instant, that would have been okay on this point?
Well, if the conforming interpretation was identified with sufficient alacrity to allow my client to exercise their choice, then yes. But the reality is that we're a very, very long way from that. And further one, perhaps the peculiar feature of this is that it had never even been identified at the relevant time that was a solution to the problem. The problem being the unlawful interference with my client's freedom of establishment. And so at the time at which my clients departed, there was no case law that said, my clients had identified as the problem, if I can put it that way, but the solution now argued for had not even featured in the authorities. And so what's happening is, by virtue of the passage of time, that the revenue is, if I can put it this way, I don't mean any criticism, able to take advantage of the subsequent development of the case law to find a conforming interpretation that is read back into the statute when the statute evinces no intention on the part of Parliament for there to be such an option at the relevant time.
Is this not just a part of a consequence of our declaratory theory of interpretation?
Yes and no.
This happens day in, day
happens
out.
all the time, and that's why I do say that it would be no good for me to say, well, it now transpires that that this is what the law says, and I feel aggrieved about that. The reason that my client's position is different is because at the heart of what is necessary to make the unlawfulness lawful is a choice at the time of departure. And so that's why many of these cases, concerns in respect to retrospectivity simply wouldn't bite. But we do say that this case is different, and it's a case akin to Fleming, rather than a case akin to the kind that your lordship is putting to me, which is a case where, in the ordinary run of events, the court declares what the law has always been, and that's just the outcome and the circumstances. I'm conscious that Mr. Margolin was meant to be devoting a good part of his time to retrospectivity, so he's probably shooting arrows at me at this point, or at least thinking, that I'm stealing his ground. So, but I don't mean to not answer any questions in glibly saying that, but that's the kernel of the point from my client's perspective, is we of course accept the declaratory nature of conforming interpretation, but our third alternative argument, if I can put it this way under ground one, our third limb under ground one is that in this kind of case, that does not remedy the unlawfulness and can't. And you have the highest authority for that proposition. Fourth, I can be brief on this, the fourth kernel or fourth test of the threshold is where the conforming interpretation gives rise to ramifications that the court is not properly equipped to decide. So this is different to the making policy choices point. This is the ramifications point. In my submission, this is a point that has some real force. There will be winners and losers out of the retrospective establishment of such a scheme. As I say, in advance of this appeal, I have been contacted by a number of counsel acting for other taxpayers in a similar situation. Mr. Margolin's case was accelerated at a certain point in order to be joined with my appeal in order to make sure that there was a consistent answer. It affects the fiscal position of companies, individuals, private individuals, and whether or not to give retrospective effect to Schedule 3ZAA in order to rescue the historic UK statutory regime is, in my respectful position, a question for Parliament. And
the
it has.
Tribunal didn't give retrospective effect to Schedule 3.
No, you're absolutely right. Well, I mean, it comes very close to saying.
It's very important not to confuse the two things because they are totally different.
Well, my lady, I'm not sure they're totally different. But I think the Upper Tribunal recognised that it was doing something very close, even in paragraph 141, where it says this can be achieved by reading words into those sections to provide that at a time before the legislation was actually amended to comply with EU law. So there is a recognition that there is, at the very least, a connection between what is done in 2019.
Because Parliament realised that the existing legislation on its face was incompatible with EU law and that it had to be changed. So,
my lady, yes, I think I would press further and say it's not just a connection, but that there is a remarkable similarity between the outcomes. And that's the...
But so what, in a way? If Parliament was trying to achieve what the Upper Tribunal was trying to achieve, i.e. something that was compatible with EU law, it might not be surprising that they've come to a similar view about how to do it.
Well, save that the fact that Parliament did it, and in doing so, I think it's common ground, made policy choices, and in doing so, maybe there might be an objection to whether 3ZAA is a scheme. I think it would be difficult to describe it any other way. Then in those circumstances, the fact that Parliament in 2019 has solved the problem by means of Schedule 3ZAA, that Schedule 3ZAA is very similar in many respects, and that in doing so, Parliament, A, elected not to give it retrospective effect, see ample award, B, according to the Upper Tribunal, made a series of policy choices that were only for Parliament, then we say in those circumstances it's very difficult to see how the Upper Tribunal could, or this court could, do the same thing, because the proof, if I can put it that way, of the fact this was a matter for Parliament is that it was a matter for Parliament in a form that it's tolerably clear, in my respectful submission, constituted a scheme. But lady, I apprehend you're not satisfied with that answer.
You seem to be saying the same thing twice. The proof it's a matter for Parliament is that it was a matter for something Parliament did. Well, doesn't prove anything.
The proof that an amendment to the legislative regime of this kind was something for Parliament is reflected in the fact, in both A, the way in which Parliament did it, so the form in which the amendment took, and I take all of the points that it's not exactly identical, but there's a very high degree of overlap, let me put it that way, and the question as put to me was, the high degree of overlap is a point that goes against me, because of course it's the same when the court does it, because they're doing what Parliament did. But if that's right, in my respectful submission, it's a point that goes the other way. The very close overlap and similarity between them is a suggestion that this is a matter for Parliament. And the fact that we find ourselves in a position where the Upper Tribunal has read in a scheme very similar, not identical to that of Parliament, mitigates powerfully against the court doing the same.
You might be making the same or very similar submissions if, in fact, Parliament had done something completely different. Because then you would be saying, aha, there you go. There's a whole smorgasbord of possibilities.
A buffet of smorgasbord.
And it wasn't for the court to, take all the smoked salmon. So I don't think this necessarily helps you a great deal.
Well, my lady, no. I mean, I rely, I suppose, in particular on what's said in paragraph 150. I think this is extremely important. That, and maybe you're right, but maybe the way to put it, my lady, and I'm very grateful, is whatever route Parliament chose and whatever scheme Parliament made,
you'd say the same thing.
That was a scheme which involved the making of policy choices, and by virtue of that, it must be the case that this is the same here. And my lady,
But it could be said, if you look at Section 2 of the 72 Act, that both the court and Parliament were obliged to do something about this.
Yes. The question is
the ways in which Parliament can remedy the problem are different from the ways in which the court can do it.
well, yes, my lady. That is precisely my submission.
But those are obligations that are imposed both on the court and on Parliament by Section 2 of the 72 Act.
Precisely so. But the obligation imposed on the court under the 1972 Act is to read in conformity to the extent possible.
Well,
and where not
that's
possible.
not what Section 2 actually says. But anyway, let's not worry about that.
Well, my lady, I will. I apprehended that I'd addressed you on Section 2 and its relationship with Sections 2 and 3.
Well, nobody's looked at the language of Section 2, but if you don't want to, that's
my lady, I'm very happy to do so. Let me turn it up now. It's an authorities bundle, tab 8. All such rights, powers, liabilities, obligations, time remedies.
The point is that the obligation imposed by 2.1 is that all such rights, blah, 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 created or arising by or under the treaties, blah, 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 as in accordance with the treaties, or without further enactment to be given legal effect, shall be recognised and available in law and enforced, allowed or followed accordingly.
Yes.
So that's a very strong obligation, and it's an obligation that falls on the court if there isn't an enactment.
Absolutely, my lady. And then the question becomes, how does the court give effect to that obligation? My client's EU law freedom of movement rights, free movement rights, are enforceable.
Yeah.
The question becomes, how are they to be made enforceable?
Yeah.
And the answer to that is either by conforming interpretation or by disapplication of the offending legislation in circumstances where we know that the legislation offends against that free movement right. And so I don't think Section 2.1 presumes an outcome or loads the dice as regards the balance between conforming interpretation and disapplication. Now, I squarely accept that the starting question is conforming interpretation, but there's also, that's why there's the established body of case law articulating the circumstances in which, in order to give effect to my client's EU law right, it is necessary to disapply. And that strong option, if I can put it that way, follows directly from 2.1.
But you've also got to read 2.4. Provision may be made under Section 2, so that's by legislation includes blah, blah, blah. Any enactment passed or to be passed, other than one contained in this part of this Act, shall be construed and have effect, subject to the foregoing provisions of this section. So it's a very strong obligation.
So it is a very strong obligation. And my lady, the strength of the obligation is in the words, shall be construed and have effect. And we know, it's very, very well established, that there are circumstances in which conforming interpretation doesn't make it possible for that legislation to have effect in a manner consistent with EU law. And so that's why we have disapplication. And disapplication is a slightly constitutionally shocking proposition, but right at the heart of how EU law operated in this jurisdiction. Because there is a point beyond which, and the courts have established this repeatedly, and these are the reference points that I've been touching on over the course of my submissions. There are points at which the court says, in order to give effect to this very strong obligation, to give effect to EU law rights, it's necessary to disapply the legislation. That's what Factor Tame said. We're going to read out of the legislation certain provisions.
Sure, but before you get there, I think you've accepted that the logical sequence is you have to ask, first of all, whether there's a conforming interpretation which is possible. And Vodafone is an example which is important because it's, again, a case which was about the right of free movement conferred by the treaty.
It's not. I think it's freedom of capital. Yes, that's right.
Yeah, well,
Yes.
I think several rights were
Yes.
potentially in play, but they're all treaty rights
Yes.
rather than rights created by a directive. And in Vodafone, the court read in an extra exception into the statutory scheme.
Yeah, and that's because the court felt, looking at the scheme as a whole, and looking at the thrust and the grain of the scheme, this is a scheme that captures a very wide body of tax and then creates a very large list of exemptions. And so the framework and logic and flow of the scheme is that it was consistent for Parliament to add one more to a long list of exemptions. It might have been a difficult case on the margin, but in the light of that particular piece of legislation, that was something Parliament felt it could do.
No, sorry, it's got nothing to do with Parliament.
Sorry, the court felt it could do. My apologies.
That's the whole point about Vodafone. In Vodafone, the court created an extra exception in the
Yes.
legislative scheme. So some people might think, well, that's quite a powerful indication of what you can do.
So it is a powerful indication of what you can do. In my respectful submission, it's right at the outer edge of what you can do. It needs to be read alongside other subsequent authorities, such as Ample Award would be a good example of that. But critically, a core part of the court's reasoning in paragraph 39, I think it is, that I took you to earlier, is to look at the shape and grain of the scheme. And here, there is nothing on the face of the legislation as it relates to capital gains tax exit charges that evinces any indication at all to have any exemptions. If the position was there were 15 different ways in which you could defer, but none of those were lawful consistent with EU law because there was only one way that it could be done, then that would be closer to Vodafone. But we're in a different world altogether where Parliament, that's why I said earlier, my submission is the black letter submission, if I can put it that way. This is what Parliament has done. This is what Parliament intended. This is the way Parliament apprehended this legislation would operate. And there is, in my submission, no basis to suggest that at that point, a totally different mechanism for payment should be or could be read into the scheme. Now, my lady, that, if I can, that's a very helpful point at which to deal, because I need to deal very briefly, and I will be very brief with grounds 2 and 3, but I will take hopefully less than 10 minutes, to deal very quickly with section 281 question, which is one of the points relied on by my learned friend in the Upper Tribunal. I can do this really quite quickly. Section 281 is a provision which provides that where capital gains tax is payable on a gift, then it may be payable in instalments over 10 years. So it is a very different provision. It has nothing at all to do with transfers of assets out of the United Kingdom, nothing at all to do with how one might give effect to rights in EU law. And it comes back really, I think, to the point that I was making earlier about the grain and parliamentary intention. The fact that there is a mechanism within the statutory scheme in relation to, yes, capital gains tax, but a completely different iteration or form of capital gains tax, in my submission is a very weak interpretive tool by which to say, aha, I now know the grain and thrust of the legislation. It's not the grain and thrust of the legislation. That is no part of the legislation as regards capital gains tax exit charges. So we really do say that that point goes nowhere. And if it's picked up and maintained by my learned friend, then maybe I need to address it more fully in reply. So that's ground 1. I really will be less than 10 minutes on grounds 2 and 3. Mr. Margolin is going to deal with the respondent's notice and the interest in ground 4, so I really only do have those 2 points to cover. Ground 2 is closely connected to many of the points that I've been making in relation to the hypothetical nature of the entitlement in ground 1. And so I really can pick it up very quickly. I think 5 submissions. First, the starting point of the analysis is to identify the nature of the unlawful interference in EU law. That's the failure to provide, or at least an aspect of that is the failure to provide a choice. Second, The Upper Tribunal approached this the wrong way round. It found repeatedly that there was no interference with EU law if there was a right to defer. Both elements of that are wrong. There's always an interference. It's just that it might be rendered proportionate. Secondly, it's the right to choose to defer that's the key. Third, the error at the heart of the Upper Tribunal's logic was that if there is a way in which the unlawfulness can be remedied, that should be adopted. And again, you've seen from the authorities, and Routier perhaps is the key on this, that the existence of a possible lawful mechanism is not enough to give rise to a lawful conforming interpretation. That is the sort of the tempting fruit submission, if I can put it that way. Just because the court knows how it might be possible to render UK legislation conforming, that is not enough, in my respectful submission, because you have to still ask yourself all of these questions about the propriety of that step. Fourth, the conforming interpretation selected by the Upper Tribunal doesn't remedy the breach of EU law, because it doesn't grant the taxpayer the right to choose at the time. As I say, this is very close to one aspect of my submissions under ground one. Fifth, the remedy doesn't address the interference because the taxpayer doesn't have a chance to make an informed choice at the point of exit. And that comes to the point that I was canvassing with my Ladyship Lady Justice Laing a moment ago in relation to how and what choices might have been made. That leads me on to ground three. Ground three, as I said right at the beginning, is advanced in the strict alternative, which is that if you are against me and the interpolation of a novel payment framework, I won't use the word scheme, by which payment is deferred is lawful, and there was a non-hypothetical choice to take the benefit of that scheme at the relevant time, then the Upper Tribunal selected the wrong conforming construction. And you have my submission on this, so I really can do it quite quickly. The construction that it should have chosen, in my respectful submission, is rather close to that advocated for by the Revenue in its amended case in 2018. And that is that there should be deferral until the point of disposal with, as is in the case law, a time limit for that of 5 years. And the reason for that is as follows. First, it requires considerably less detailed amendment to the statutory scheme. It's simpler. It's easier. Second, it can be achieved by way of amendment to section 80 rather than section 59B. So it can be done by way of amendment to the provisions that relate to capital gains tax and exit charges. That's an advantage because it's an amendment that deals with the core point. It also goes with the grain because at least one possibility is to keep aligned the point of quantification and the point of liability. That's what section 80 does now. You leave, deemed disposal, deemed reacquisition. One way in which this might be done would be to do that in relation to deferral. You leave, actual disposal, liability arises at that point. So it's consistent with the way Parliament thought. So, how do you quantify it?
Is it at the exit date or the sale date?
Well, so my submission is that the better way to do it would be to say that it's quantified at the point of disposal. But
that's rather an odd idea because the whole point of the exit charge is that, as I understand it, that which the European Court has said works, as it were, is that a taxing authority should be allowed to levy taxes in respect of things that happen within its territory. Now, take a case where there's an exit on day one.
yes,
3 years later, there's a disposal of the asset. During those 3 years, things, as it were, have happened which have nothing to do with the territory of the taxing authority.
yes.
And that means, so what you're proposing with that solution seems to me to go very much against the grain of the legislation, which is that it's concerned with things that happened while the company or the trust, as the case
It's no longer resident.
was here.
So, my lord, and that's why I say it's simply one way in which it would be doable. The other way to do it would be to maintain it at the point, you calculate at the point at which there is a departure, and then the liability falls due at the point of disposal. My lord, again, I mean, I don't need to make the submission again, but the very fact that we can canvass between ourselves different ways in which this might be done rather goes to my ground one. So in my submission, if the court considers that it should engage in creating a framework, I choose the word advisedly, at all, my respectful submission, the simpler and the more straightforward scheme is one that allows for payment at the point of realisation. And the judgment deals with this at paragraphs 146, 147,
Would this then have a consequence that your clients wouldn't have to pay any tax?
yes.
So it's a rather adventitious interpretation, isn't it?
Well, I mean, my lord, yes, save the fact that this was the revenue's submission.
Well, it's not entirely clear to me that that's exactly what.
Well, that may be right. Am I learning if I may?
It may be that they were saying that the, as it were, the liability
arises
accrues in the year of the exit, but that you can have effectively a deferral of the obligation actually to pay until disposal.
That may be right, my lord. That may be right, and my lord, if I may well say that that's how the revenue understood the point to be put. My lord, the reality is that either my client is going to be subject to a charge to tax in respect of a statutory regime that was unlawful at the relevant time, or my client is not going to pay that tax. Those are the two outcomes. And we do not shy for a moment away from the fact that were the appeal to succeed, there would be no liability to tax. And that's why right at the beginning I said, look, there's a sort of underlying suggestion that this is some kind of impropriety or opportunism, and so perhaps having my cake and eat it, I made the suggestion that the revenue is being rather opportunistic in relation to its evolving case. But the core of my submission is that actually neither of those points really matter. What really matters is, can a conforming interpretation be read into this legislation at all? And if it can, my submission under ground 3 is, it's, in my submission, not just as good as, but a better solution to have deferral until realisation. And if it transpires that the consequence of that, well, it does transpire the consequence of that is that my client doesn't pay any tax. Well, my lord, that is not the primary question the court is asking itself, or indeed really, in truth, a part of the analysis at all. The analysis is slightly more bloodless than that, if I can put it that way, and it turns on the question of statutory interpretation and principle. So I don't say for a moment that both sides of the court can't make submissions of that kind, but I don't think in truth they really take the case very far forward. So that's only in a very strict alternative. You know precisely why HMRC is against it. You know precisely why I make the submission, my lord. But I don't make it in a purely opportunistic and adventitious way. I make it because I say actually it is a perfectly proper submission as to the better way to give effect to EU law. As I say, my final ground relates to interest, but Mr. Margolin is going to deal with that. I have strayed 3 minutes past my time, but I'm very grateful unless the court has any further questions.
Can I just ask this question? The way that the European Court seems to look at things when it's been looking at these cases is that there won't, as it were, be a double charge to taxation because under the regimes it's looking at, when let's call it a company for a minute, to keep it simple, when the company moves from one country to another, the gains which will happen after the move are calculated by as I understand it, by reference to the value of the assets at the time of the move. So in other words,
yes,
the capital gains that will be payable in the new country
reflect
the fact that the establishment is now there. Because there is some talk in the cases about
double taxation, and indeed, as you saw in 3ZAA, there's the specific provision made for taking into account the possibilities of double taxation.
Now, is there any evidence in this case about how if you were right in your submissions, any pre-exit gains might be taxed in the new country?
In Cyprus?
Yeah.
There is no evidence in this case that I'm aware of that addresses that point. Certainly Mr. Panayi's witness statement and the solicitor's witness statement do not, so far as I'm aware, address that point at all. I would say I'm cautious about giving evidence, but that of course would presume that I was in a position to give evidence, my lord. Something on which it's fair to say that Cypriot double taxation law is not
right, but you're saying it's not, there was no evidence.
I will, if I may turn my back for a moment, my lord, and check. Well, my lord, that's right. There was no evidence before the first tier tribunal in relation to that question.
Right, and that leads on to the second question. The EU cases recognise, we've been talking about obviously the rights of taxpayers here, but the EU cases also recognise, I don't know whether you call it a right or not, but
a legitimate objective.
A power of the state to levy taxes in respect of their own territory, and in particular in respect of a period when someone was there. Now, it seems to me arguable that what you've been putting forward doesn't give due weight to that value or right or whatever you call it.
So I certainly hope that when going through the EU case law, I specifically picked up on the fact that the authorities established that it is a legitimate objective to, consistent with the national objective in respect of taxation, to tax at the point of exit, in principle. And the critical words are the in principle. And that's why what EU law is doing, in my respectful submission, is striking a balance between a concern for free movement and freedom of establishment and a concern to ensure that, if done properly, proportionately and lawfully, member states can also tax in respect of accruals within their jurisdiction. And that's why much or most of the case law focuses on the proportionality question, because that's the question that the court has to decide. Now, one of the unusual features of this case was that actually there was an upstream question about whether my clients could take the benefit of freedom of establishment at all. And that therefore got referred. But you're right, my lord, that much or most of the case law is asking how to, or how lawfully to give effect to both of those things. And to the extent that I haven't lent sufficient weight to the interests of the member state, that reflects, I suspect, two things. Firstly, the fact that the case law prices that in, if I can put it that way. Secondly, the fact that I suspect Mr. Fell may give you more submissions in relation to that, but also because at the heart of this case is the established fact that there was not a lawful scheme. And so that is the starting point. That's the kind of launching off point, and that's box one, if I can put it that way. And so, therefore, that is the sort of point from which the analysis flows, at least in my submission. And I think, in fairness to the Upper Tribunal, possibly what they're saying when they say in 130 is they're not sure that they accept that. And that's why I say that they're wrong in paragraph 131. They've misunderstood what is lawful and unlawful in this area. I'm not sure that's a full answer.
No, it's a very helpful answer. Thank you.
I'm very grateful. Yeah. Unless there are any further questions, my ladies, my lord.
No, thank you very much indeed. Ms. Margaret.
Bear with me while I do a little bit of logistics. My ladies, my lord, I'm hoping that in circumstances where Mr. Johnston has covered quite a lot of the ground, I can largely focus my submissions on the particular circumstances of my appeal and on some of the matters which Mr. Johnston hasn't addressed, although I'll have a little to say on some of the matters which he has covered. In a nutshell, we say that the Upper Tribunal was wrong to find that Redevco couldn't rely on the principle of legal certainty, A, as a matter of fact, and B, as a matter of law, on the grounds that it must be taken to have known that domestic legislation could always be subject to a conforming interpretation which could retrospectively alter its terms, even in potentially ways which were unseeable. And our grounds 1 and 2 touch on that point. We also, and this is ground 1, respectfully submit that the Upper Tribunal was wrong to find that a conforming construction could be given to Section 59D of the Taxes Management Act, which we say was in contravention of the principles of legal certainty and legitimate expectation. We also say that the conforming or purportedly conforming construction of Section 59D, which the Revenue proposed and which the First-Tier Tribunal and now the Upper Tribunal have adopted, goes beyond the legitimate grounds of conforming interpretation so as to amount, as it's put in our ground 4, to impermissible judicial legislation. We say that the First-Tier Tribunal and the Upper Tribunal were bound by a series of decisions of high authority, House of Lords and Supreme Court cases culminating in Routier, with which their decisions were ultimately, we say with respect, inconsistent. We also say, and this is our ground 3, that the Upper Tribunal erred in its identification of the relevant breach of EU law. I won't have much to say on that because that ground's been traversed fairly fully by my learned friend. And we say that the Upper Tribunal erred in the way in which it dealt with interest. That's our ground 5, although as will now be apparent from our supplemental skeleton, our position on what the Upper Tribunal actually did and thought it was doing in relation to interest has, to a degree, moved on from how ground 5 was originally framed. In dealing with interest, I'm going necessarily to have to say something about the way the Revenue's position on interest evolved in Panayi and the way in which that was then carried over in respect of our appeals. So to that extent, it may be that my submissions on interest go to the Panayi appeal, but it may well be that depending on how the Revenue's position evolves, my learned friend may need to come back on some Panayi specific matters on interest. I hope not to any great extent. So I'm content to, with respect to adopt my learned friend's submissions on a number of points, including, as I say, for example, the identification of the breach of EU law. Subject, therefore, to the court, I'm proposing to structure my submissions in this way. First of all, I propose to make a number of preliminary observations, in part at least, to help in defining the parameters of what seems to be an issue where the battle lines are drawn. I'll then deal very briefly with the procedural history of the inquiry and the appeal, and the factual background to the appeal, which is largely covered in the decisions of the First-Tier Tribunal and the Upper Tribunal. Look very briefly at the legislation insofar as it relates to Redevco's appeal as opposed to Panayi's appeal. Look fairly quickly, in light of the submissions you've already received, at the principal authorities in relation to conforming interpretation, and then slightly more fully at the authorities in relation to legal certainty, and then move on to interest, and then something very briefly in relation to disapplication, which is raised in HMRC's Respondent's notice. So, by way of preliminary observation, I'd make the following remarks. The obligation of conforming interpretation, that is, to read national legislation compatibly with EU law, derives from national courts' duty of cooperation and the general principles of supremacy and effectiveness of EU law. It has an important role to play in ensuring that EU law is effective and that taxpayers, among others, have an effective means of asserting and giving effect to their EU law rights. But as the case law of the Court of Justice shows, there are important constraints on that obligation, and in particular, national courts aren't required to interpret legislation in a manner which is contrary to its wording or the will of Parliament, and retrospectivity, which might be said to be inherent in the process of conforming construction, mustn't, we say, contravene the general EU law principle of legal certainty, and that's particularly acute in the two critical areas of criminal law and tax. We say that the principle of legal certainty requires, among other things, that the terms of legislation must be established clearly in advance, and that failure to comply with that principle may of itself infringe the right of individuals to assert and give effect to their EU law rights. We respectfully submit that the conforming construction adopted here falls foul of those two constraints, and that it goes beyond what might reasonably and properly be called interpretation. To borrow the phrase which you've heard already today from Lord Steyn in Guidan, it crosses the Rubicon and strays into judicial legislation, and in doing precisely that, it offends against the principle of legal certainty. And the effect of that in this case is retrospectively to deprive Redevco of the ability to take what was a momentous commercial decision on migration on the basis of its analysis, its perception of the lawfulness or unlawfulness of the legislation as it was drafted at the time, a matter which, as is now common ground, although the precise nature of the breach is contested, was on its face incompatible with EU law, and its analysis of the unlawfulness of the legislation was further reinforced by the advice that it took. Furthermore, the conforming construction has those unfortunate effects in circumstances where we say there's no obligation on the national court under EU law to do anything other than disapply or not to apply the tax charge. My friends covered that to a degree when we were looking at Section 2 of the 1972 Act a little while ago. Specifically, we say there's no obligation under EU law to interpret the UK legislation, irrespective of what it actually provides on its face, in such a way as to provide for a deferral regime. The sole obligation under EU law, under Section 2 as it's been interpreted in the cases, was a negative one of not applying an immediate tax charge on exit, which, as the case law now clearly shows, couldn't be lawfully imposed even if quantifying the charge at the date of exit, subject to some sort of provision for deferred payment, might have been lawful, as the cases such as National Grid Indus and DMC and Verda Labtech now show. This isn't a case, and this is going back to a question which my Lady Justice Laing raised. This isn't a case like IDT card services, for example, where there was a positive obligation under a directive to ensure, if possible, that the domestic legislation properly implemented the VAT regime, of a kind which a taxable person could probably be taken to be aware of. There's a further important point to keep in mind. As I've said, as a matter of EU law, the conforming construction approach, as we'll see, is limited by the principle of legal certainty, and that's particularly so in criminal cases and in tax and similar cases where a construction will have financial consequences. We would observe, and this goes to a question which my Lord Justice Miles raised, we would observe that an interpretation arrived at by means of what's referred to as the UK court's highly muscular approach to a conforming construction is inherently likely, depending on the circumstances, to increase the risk of conflict with the principle of legal certainty, certainly by contrast with an ordinary approach to the construction of domestic legislation. precisely because of the extent of the judicial rewriting to which the relevant legislation may be subjected. And where that's the case, we say not only is such an approach not required under EU law, but it would actually be contrary to general principles of EU law and specifically legal certainty. Ultimately, our position is that Redevco was entitled, in the light of what the legislation actually said at the time, and reinforced by the advice it took, to act on the footing that the legislation here, without any provision for deferral of the payment of the charge, was or was very likely to be unlawful, both when it decided to move its place of effective management to the Netherlands, and when that decision was actually implemented. To expect it to have ordered its affairs on the basis of some fundamentally different regime, I'll try for now to avoid the word scheme, but you'll know what I mean, some fundamentally different regime which a tribunal, or indeed HMRC for their part, might hypothetically consider it appropriate to introduce many years later, and which involves a number of choices such as period of deferral, whether to defer by way of instalments, and if so over what period, or to impose on realisation, both of which might seem to be reasonable choices, and both of which now feature in, as we'll see, Schedule 3ZB, perhaps also in relation to interest, penalties, and security. To expect it to have ordered its affairs on that basis, we say is to ignore the principle of legal certainty encompassing general approach of non-retroactivity and the protection of legitimate expectation. Redevco was rightly of the view, consistently with the advice it took, that the legislation was or was very likely to be unlawful, and was therefore, we say, entitled to conduct its affairs on the basis that the exit charges would therefore be struck down. This appeal primarily concerns the question of when a national court can apply a conforming interpretation to legislation which is incompatible with EU law and when it can't. There are two authorities at the highest level, Fleming and Routier, which we say are entirely consistent with other earlier and more recent high authorities in setting out what a court can reasonably and can't properly do. Those authorities were distinguished by the Upper Tribunal, and the Revenue would have this court distinguish them on grounds which, with respect, as we'll see, are flawed. And it's significant that the Revenue's analysis proceeds really directly to some of the Court of Appeal and High Court authorities, like IDT and Vodafone 2, on how the process of conforming interpretation is to be undertaken once it's been determined that such an approach is a proper one, rather than grappling, as we say, is necessary in the first instance, with the authorities that show what it is that a court can and can't do. The European case law now establishes that the imposition of an exit charge taxing unrealised gains upon relocation to another member state is in principle discriminatory in that it constitutes an interference with the freedom of establishment. It may be capable of being justified by the objective ensuring the balanced allocation of powers of taxation between member states, provided that it's proportionate. Requiring immediate payment was disproportionate. Provision must therefore be made to allow a taxpayer to defer payment. And payment by annual instalments over a period of 5 years or 10 years will be compliant with EU law, but so too may, of course, many other measures, such as payment on realisation. I obviously bear in mind the observation that my Lady Justice Laing made earlier on, that it might be rash for the Revenue, or might have been rash for the British government to seek to put in place a regime that provided for payment in fewer than 5 instalments. But we don't know that that wouldn't, in fact, be appropriate. So it doesn't necessarily mean that a period of 5 years is the absolute minimum which would be regarded as compliant. I should also say that although National Grid Indus, DMC, Verda Labtech are now fairly well established, it would appear that those cases may not be the last word from the Court of Justice on the subject of compatibility of exit charges. A request for a preliminary ruling having been lodged in June last year in a case called Gaynor. I'll just give you the reference. It's Authorities Bundle 10, tab 102, beginning at page 3171. That's a case concerning the liability of natural persons to pay exit charges, and on Articles 21 and 45 of the Treaty on the Functioning of the European Union. And one of the questions referred is whether the provisions of EU law, including those articles, must be interpreted as precluding domestic legislation which provides that a change of residence by natural persons subject to tax on income from unrealised gains results in the immediate levying of the tax or payment instalments by a period of no more than 5 years, instead of deferring payment until realisation. So we might have all thought that the cases in the authorities bundle were represented the last word on the subject, but perhaps they don't. In any event, it's clear from the current case law of the Court of Justice that the charge to tax payable 9 months after the end of the relevant accounting period was incompatible with EU law, and therefore effect should not be given to it, which is to say that unless the legislation applicable at that date can be given a conforming construction, there's no basis on which an exit tax charge was lawfully payable here. And of course, the conforming construction doesn't go into the same level of detail as Schedule 3ZB or Schedule 3ZAA, but it is, so far as is relevant for present purposes, functionally equivalent to the measures which Parliament subsequently put in place. Redevco's migration to the Netherlands was found by the first-tier tribunal to have been primarily for commercial reasons, but given that the migration did result in tax advantages for Redevco, tax considerations, it found, certainly played a part in the decision. That's paragraph 25 of the FTT's decision, core bundle, page 138. There's no room for any criticism.
Can I just ask you about that? What tax advantages was the FTT talking about there?
Well, it's tax considerations. I see. Forgive me. Well, if one looks at what's
Sorry, tax consideration. It says migration did result in tax advantages. Yes, it's both actually. In paragraph 25. Is the tribunal there talking about the tax advantage of not having to pay tax, or is it exit tax, or is it talking about something else, which is more probable to me?
I think it's talking about something else. I'll find it if I can, but I don't think it's saying that the migration was undertaken simply for the purposes of avoiding an exit tax. That wouldn't make sense in any event.
So it must be talking about other advantages from making this move, perhaps advantages under the local tax regime or whatever.
Well, I think the corporation tax regime in the Netherlands would be beneficial in certain respects by comparison with the corporation tax regime here. So I think that was part of thinking, but the commercial reasons which were said to have been foremost in Redevco's mind were to do with effectively moving the management of an outlier company, which was part of a subgroup, to the Netherlands, where the rest of the companies within that subgroup were managed. So I think there were thought to be efficiencies of that kind, and that finding wasn't challenged in the Upper Tribunal.
No, but that being so, what's one to make of that? Because that just seems to be saying that in deciding on the exit, one of the things that was taken into account was tax considerations other than this thing about the argument we're now having, as it.
Well, I think where it goes is this, and we said there's no criticism that can be made of Redevco for having considered whether there might be tax advantages to migration, and there's no criticism that can be made of Redevco for having taken Specialist Leading Counsel's advice in relation to the compatibility or incompatibility with EU law of the exit charge regime. There's no suggestion here, and never has been, any suggestion of artificiality or abuse. I think the point was simply that this was, as one might expect of any reasonably competent, diligent company belonging to a multinational group, bound to take advice on and consider the tax implications of a migration as part of its decision-making process, albeit the process was driven, as was found, primarily by commercial considerations. I think that's as far as it goes, my lord. But as I say, there's no suggestion of any artificiality or abuse. It acted openly, notified the revenue in advance of its decision, and stated that it would treat any charge on migration as unlawful, and drew the revenue's attention to that in its final return. The only thing Redevco could do in terms of exercising its EU law rights, in terms of vindicating those rights, it might be so, was to act on the legislation on its terms, taking a view that was informed by or reinforced by the advice it had taken as to the compatibility of the legislation with EU law, and either migrate or not. There was no advanced ruling procedure. There was no assistance from HMRC as to how the legislation might be applied administratively to conform with EU law. And of course, once it had taken and implemented the momentous decision of migration, there was no going back or no coming back. It would either be liable or not liable for a tax which it was unlikely ever to suffer had it remained in the UK. Now, it's always...
Can I just check one point, Mr. Marglin? The Upper Tribunal recorded that your clients didn't challenge the finding in paragraph 26, that it was more likely than not that the migration would have proceeded in any event, irrespective of the advice of leading counsel. Is that still your position?
We're not in a position to challenge that, but that's, in my respect for submission, unsurprising, because...
I'm not worried about why you're not challenging it. I just
But no,
want
it's
to
not.
check that you aren't challenging it.
We're not challenging.
Okay, all right, thank you.
Sorry, as I was going to say, I mean, it's always going to be the case that legislation which is incompatible with EU law could have been drafted in a way that was compliant, but here we know that wasn't the case. What, in effect, the commissioners are seeking to do is to utilise the taxpayer's protection, which is to say the obligation of conforming interpretation to ensure the effective protection of its EU law rights, so as, in substance, to amend the legislation which was non-compliant, and to do so retrospectively, to render it EU law compliant, and effectively, therefore, to nullify the incompatibility with EU law, and all to the taxpayer's disadvantage. And we do say that there's an important distinction made between two quite different sets of circumstances. One is where changing the legislation by a conforming interpretation would impact upon a taxpayer's decision-making process, and where it wouldn't. And where it would have done so, we say that's the case here. A conforming interpretation stands to contravene the principle of legal certainty and wouldn't ensure an effective remedy. The cases on which the commissioners rely are primarily cases of the latter kind, where there was no impact on a taxpayer's decision-making. In Prudential and FII, a conforming interpretation was used to establish what the charge to tax should have been in order to quantify claims for recovery. There was no issue of legal certainty there. The subject transactions involving the payment of dividends were wholly unaffected. The question was simply what the tax should have been by reference to what compliant legislation would have looked like. In IDT, as we've seen, and I'll come back to it, but only very briefly, there was a potential legal certainty issue, which led Lady Justice Arden to rehearse the relevant case law of the Court of Justice and to explain that was outweighed or even negated by the fact that there was a positive obligation to impose VAT under the 6th Directive, and it was clear what the result intended by the 6th Directive was. The taxable person had sought to exploit the mismatch between the Irish and UK regimes to undertake transactions which clearly should have been taxed, but without paying that tax. The conforming interpretation adopted enforced the imposition of the tax required by EU law, consistently with the directive, and hence was entirely foreseeable. In Vodafone 2, the conforming interpretation, as we've seen, ensured that if the taxpayer was exercising its freedom of establishment, it actually had to establish a business in the member state. There couldn't be any objection to the introduction by a conforming interpretation of a requirement that it actually had to establish. That didn't in any way affect its decision-making, and if it never established, it wasn't exercising EU law rights anyway. So all the conforming interpretation did there was to identify the circumstances in which the taxpayers actually had a treaty right. Fleming, which you've been taken to in detail, on which I place considerable reliance, is the key authority in the other situation. There, UK domestic law was incompatible with EU law in that while it permissibly reduced a time limit, it did so without a transitional period. The question was whether a transitional period could be read in or applied by the courts. I'll come back to that distinction in a little while. Whether by way of a conforming interpretation or partial disapplication, ultimately doesn't matter which, but in any event, so that those who hadn't issued claims within what would have been an adequate transitional period or period of disapplication were out of time. By a majority, the House of Lords rejected that approach. The court couldn't second guess what taxpayers would have done had the law been materially different. And Redevco, we say, is to that extent in an equivalent position to Fleming. Not only is the court not, in our respectful submission, in a position to second guess what Redevco would or might have done had the legislation deferred payment of the tax for 5 years, but in fact there's every reason to suspect it wouldn't have migrated, given that it took tax into account, as we know. It wasn't intending, we'll touch on the finding in this regard in a moment, it wasn't intending to sell the assets. So migration with deferral would have attracted, albeit over 5 years rather than in one fell swoop, a charge that Redevco would otherwise never need to pay at all.
How does that tie in with the finding of the FTT that it's more likely than not that migration would have proceeded in any event, irrespective of the advice of leading counsel?
My lord, it's a different point. I'm talking here of the situation where if there had been legislation in place at the time which provided for deferral over 5 years as provided for by the conforming construction adopted by the tribunal, we say it's very unlikely in those circumstances it would have migrated. It's a different question from whether or not they'd have migrated had leading counsel's advice on the legislation as it appeared on its face at the time been different.
Sorry, I don't follow that. But as I read the finding, I may have misunderstood the finding, but the finding seems to be, supposing that leading counsel had actually said, sorry, you are liable to, in other words, this UK statute is valid. In other words, no problem under EU law. As I understand it, what's being said is that your clients would have migrated anyway. Because he says, I find it's more likely than not that the migration would proceed in any event, irrespective of the advice of leading counsel.
Well, there's also, my lord, a distinction between what leading counsel advised and, as I put it, the perception or analysis of Redevco of the incompatibility of the legislation on its face with EU law.
Yeah, but supposing that a counsel had said, actually, there isn't this EU point. It's just, you've just got to cough up when you exit.
Well,
and that seems to be what the finding is.
I'm not sure. I'm not sure whether understood in the context of the evidence before the FTT that can really have been what the tribunal meant. I mean, the reality is, it's a point that I think is referred to in the decision, and we'll, if we look briefly in a moment at what leading counsel said, there's a plethora of references to other members of the tax bar and other commentators, all being of of one mind in relation to this. I think in that context, one can understand that the exercise that leading counsel was engaging in probably wouldn't have moved, or may not have moved the dial all that much because of the universal or near universal understanding of the incompatibility of the legislation on its face with EU law. But there it is.
That's not really what paragraph 26 says at all, is it? Apart from that.
Well, not
Paragraph 26 says, although the evidence of Mr. Drury that the decision to migrate was not a foregone conclusion, and that Mr. Faber was that the migration would not have occurred if Redevco had not received positive advice. The contemporaneous documentation does not support such assertions. As such, I find it more likely than not the migration would have proceeded in any event, irrespective of the advice of leading counsel. So what's being said is, whatever, when the chips were down, they were advised about the compatibility or incompatibility, they were going to go. Isn't that what paragraph 26 says?
My lady, if I go back to the first answer which I gave to my Lord Justice Miles, I think that is considering a different factual set of circumstances from my submission about what the position would have been if there had been a specific deferral regime in place at the time.
Okay.
But that seems to, with respect, a difficult point, because if leading counsel had said, actually, you are on the hook under domestic legislation, the finding of the tribunal is you would have gone anyway. That's as I read it, at least. Because just before, in paragraph 24 at the end, it says, I've got to make findings, whether it had happened at all, if the advice from Redevco received from leading counsel had been different or less positive. So supposing that leading counsel had given different advice, saying, sorry, you are on the hook, the tribunal judge is saying you would have moved anyway. Now, it seems to me quite unreal to say in those circumstances that if you had instead been given a choice between leaving and coughing up, sorry, that's a bit of a...
I think we all know what
paying immediately, or leaving and paying the same amount but over 5 years, the decision would be any different. I mean, it just seems to me wholly unreal. But maybe you can...
Well, I'm not sure that by having another go at answering the question, I'm going to improve the quality of the answer. I'm not sure it's a point I really need to press anyway. I was going to move on to Routier. I'll come back to Routier in slightly more detail. You've heard something about it already, and we've heard some of the court's observations in relation to its significance, which I'll try to address. But we say that what one can get from Routier is that the Court of Appeal had tried to replace a restriction in the domestic legislation which breached EU law with a new one that didn't, but which was considered to represent the minimum necessary to comply with EU law rights. And we say that, properly analysed, the Supreme Court's decision makes clear that approach strayed beyond the bounds of conforming interpretation. There was no need, once the offending restriction was removed, to devise a new restriction with a view to giving effect to the minimum level of protection that EU law would allow. We say that that principle, if that's how Routier is properly to be understood, is one which HMRC's suggested approach as endorsed by the tribunal offends against, because the conforming interpretation leading to deferral by 5 annual instalments does in substance represent the replacement of a non-compliant restriction of immediate payment with a measure designed, so it's said, to give the minimum deferral, which to date EU law is known to permit, but in a way which, in the circumstance of this case, is actually designed to catch out, if you like, Redevco and to take effect in a way that's prejudicial to Redevco's position by comparison with its understanding of the incompatibility of the domestic legislation on its face. Drawing those threads together, we say conforming interpretations engaged when it's needed to ensure the effective application of EU law. There was no actual obligation in EU law at the time to impose an exit charge. That's changed now in light of ATAD, but it's accepted that that was not an obligation at the time. The requirements of EU law will be satisfied by simply disapplying the charge, and we say that that can be the end of it. A conforming interpretation, as we'll see, is limited by, controlled by, one might say, the principle of legal certainty, and where the retrospective introduction of new conditions would or might impact upon a party's decision-making, legal certainty will be contravened. Conforming interpretation can't, we say, be used to improve legislation to make it accord with the bare minimum that EU law might have required. And as I've said, deferral by payment over 5 years isn't the only available and EU law compliant solution. And here, in effect, HMRC are seeking to use an obligation of conforming interpretation not to give effect to the taxpayer's rights, but in a sense to achieve the very opposite. And in that sense, there was some discussion by the court with my learned friend of how, in his appeal, how the parties' respective positions could be somewhat pejoratively characterised. We do say that here it can properly be argued that HMRC are seeking to obtain the benefit of an extreme outcome by way of moulding Section 59D in a way that's intended to fill a legislative void and would never have been apparent to a taxpayer at the time. I'll deal very quickly with the factual background, if I may. We've touched on the fact that the place of effective management was moved to the Netherlands in January 2008. We've looked at the findings in paragraph 26 and the context in paragraphs 24 and 25 in relation to that. The background, as summarised in paragraph 14 of the FTT's decision, so that's at page 132, was that in late 2006, the management of Holding, which is to say Redevco Properties Holding, whose managerial headquarters was in the Netherlands, started to consider the feasibility of moving the management of Redevco to the Netherlands in order better to coordinate its management with that of the group, and in particular with that of the securitized subgroup, of which it was the only non-Dutch managed member. Advice was taken from leading counsel. I'm not sure we need to go there now, but the written note of his advice recorded at page 46 of the supplementary bundle, and as was set out in the FTT's decision at paragraph 17, which is on page 133 of the core bundle, that counsel was strongly of the view that corporate exit charges were contrary to EU law. Counsel's view is a widely held one. Indeed, he believed a universal one at the tax bar. There's some references to cases concerning individuals and to a paper on exit charges prepared by the Law Society's International Tax Subcommittee, coming to the same conclusion. Counsel's view is expressed in paragraph 11. And if one then goes to paragraph 19 in the FTT's decision over on page 134, there's extensive citation there from the Law Society paper, which was later published in August 2007, expressing without qualification the view that in its present form the exit charge provisions were in breach of EU law, but that some form, this is paragraph 6 towards the top of page 134, some form of deferred charge would be a more acceptable and proportionate measure. Towards the bottom of the page, in internal paragraph 39, on the basis of our analysis, we conclude that exit charges in their present form are in clear breach of Article 43. Paragraph 42, right at the bottom of that page, a modification of the rules is required. The starting point could be the postponement of the charge to tax until the realisation of the asset by the company with a 6-year period. Over on 44, reference to until a coordinated regime on exit charges can be agreed. We believe that gains accruing before migration aren't taxed in the UK, and gains which have accrued during residence but not realised before migration are taxed on a deferral basis. The other important finding, we say, is in paragraph 20 on page 135. Sorry, forgive me, it's paragraph 21, and it's 21.21.3, the relevant part of which is over on 136. The properties owned by Redevco were long-term held assets, and there was at the time of migration no foreseeable expectation of their sale beyond group ownership. However, as in fact was the case, all of the properties were sold on the 22nd of November 2011 by Redevco, albeit to another group company, so there was no influx of cash into the group. I'm not sure it's in dispute that the views expressed in specialist tax publications at the time, and indeed both up to and following migration, were without exception consistent with the advice given by counsel and the view expressed by the Law Society subcommittee. And in terms of the state of the migration, as noted in the previous subparagraph on page 135, Redevco notified the Revenue of its intention to cease to be resident, and that in its view the exit charge taxes were invalid under European law, but after provision of an adequate guarantee, HMRC granted consent to the migration, which took place in January 2008. The inquiry, I'm going to deal with this very briefly, was opened on the 14th of December 2010, as one gets from paragraph 21.4 on page 136, was eventually concluded by a final closure notice dated the 2nd of August 2021, as referred to in subparagraph 8 on the same page, which stated, so far as material, the inquiries had been concluded, and the reason given for the conclusion, the reason for our conclusion, it was said, is that the charges set out above arise under the domestic legislation and are not incompatible with EU law. And that decision was appealed in August 2021 and then proceeded in the first-tier tribunal. If we can move now just to look very briefly at the relevant legislative provisions insofar as they relate to our appeal. Authorities Bundle 1, it's behind tab 16 at page 150. Contains section 1845 of the Taxation of Chargeable Gains Act, which, so far as material for our purposes, in relation to deemed disposal of assets on companies ceasing to be resident in UK, provides that this section, section 187, apply to a company if at the relevant time it ceases to be resident in the UK. Sub 2 should be deemed for all purposes of this Act to have disposed of all its assets other than assets accepted from this subsection by subsection 4 below, immediately before the relevant time, and immediately to have reacquired them at their market value at the time. And if one then looks at paragraph 10A of Schedule 9 to the Finance Act 1996, that's the provision in relation to loan relationships, and and in similar terms, in sub 1, it's provided that applies if at the relevant time a company ceases to be resident in the UK. And in the case of a company that isn't resident in the UK, an asset or liability representing a loan relationship with the company ceases to be held for the purposes of a permanent establishment of the company in the UK in any circumstances not involving a related transaction, subject to the exception in 1A. And again, in 2, there's the deemed assignment and reacquisition that gives rise to the charge. Tab 5 of that bundle starts at page 56, but the relevant page is page 59. You'll see section 59D, which is the provision which was the subject of the tribunal's conforming interpretation. One notes that that's a general rule, as it's put, as to when corporation tax is due and payable, to be found in a wholly different part of the tax code from the specific provisions in relation to exit charges. But one sees that provision provides that corporation tax, as a general rule, for an accounting period is due and payable on the day following the expiry of 9 months from the end of the accounting period. And then, if I could ask you, please, to go to tab 6 in the authority bundle, beginning at page 64. You'll see there Schedule 3ZB of the Taxes Management Act, which was inserted by the Finance Act 2013. And this is to do with, as one sees on page 64, exit charge payment plans. And as one sees from page 65 in relation to companies ceasing to be resident in the UK, and providing, as one gets from 66, that part of the schedule, and part 3 of that schedule, applied where an eligible company ceased to be resident in the UK, became resident thereon in another EEA state, and was liable to pay qualifying corporation tax in respect to the migration accounting period. And then it makes provision for exit charge payment plans if certain conditions are met, as set out in sub paragraphs 4 to 6. The current version is in the next tab because there have been quite substantial amendments. For present purposes, I simply make the point that in a way that's very similar to the equivalent provisions in relation to trusts, and in both its original and current versions, Schedule 3ZB is quite lengthy and involved. In the original version, it permitted a taxpayer to enter into an exit charge payment plan in accordance with either the standard instalment method under paragraph 13, so that's behind tab 6 at page 90. The realisation method, which is dealt with at paragraphs 14 to 17, which are at pages 92 to 98, 99, and which provided for deferral until realisation of the relevant assets or the 10th anniversary as a sort of long stop of the end of the migration accounting period, or a combination of the two methods. And the original version of Schedule 3ZB also made provision for, among other things, the running and payment of interest, permitted HMRC to require provision of security in certain circumstances, and also laid down penalties in certain specified circumstances. Schedule 3ZB in its original form was treated as coming into force on the 11th of December 2012 in relation to an accounting period of the relevant day, which is to say the first day of the period, 9 months beginning immediately after the accounting period, which in Redevco's case would have been the 16th of October 08, if that fell on or after the 11th of December 2012, because that's when the relevant legislation was announced. I'm not going to say very much about section 281, safe to mention that, as I think my own friend may have mentioned, it's perhaps a surprising proposition that Section 281 should contain the answer to the question here. The Upper Tribunal's decision at paragraph 111, at page 76 of the core bundle, records my submission before that tribunal that it was eccentric for HMRC to suggest that a conforming interpretation could be moulded by reference to Section 281, but that the submission that Section 281 had relevance to these appeals just goes to show the range of choices facing the tribunal in adopting a conforming interpretation. I'd also observe forensically, in the slightly pejorative sense in which that word's sometimes used, that the Section 281 point is one which was raised, if I'm not mistaken, for the first time in HMRC's skeleton argument for the Upper Tribunal hearing, which might be thought to suggest that it's not exactly an obvious solution to the issue here. But if one looks at it, and it's behind tab 16 at page 152 of volume 1 of the authorities, one sees it's to do with where the whole or any part of any assets to which the section applies is disposed of by way of gift or deemed to be disposed of under section 71.1 or 72.1. There are specific assets identified in subsection 3, land or an estate or interest in land, shares or securities of a company which immediately before the disposal gave control of the company to the person by whom the disposal was made or deemed to be made, and any shares or securities of a company not within B and not listed on a recognised stock exchange. And the suggested additional wording, which the commissioners propose could be read into section 281, as they put it, for example, as a new section 281 1A, can be seen in the supplementary bundle at pages 180 to 181 behind tab 15. And right at the bottom of 180, one sees the proposed wording is that subsection 2 below applies where a chargeable gain arises and the application of section 59D Taxes Management Act 1970 would result in a prima facie breach of EU law. I think I've made the point briefly already, but it's surprising in my respectful submission that one roams quite so extensively within the tax code to find a provision of that kind as a solution to the problem here. As I've said, I don't think I need to address you in relation to the correct approach to identifying the incompatibility with EU law, the provisions, the correct approach rather, we dealt with one another friend, and it's to be found in the National Grid Indus case. So one moves on then, if I may, to the principles of conforming construction, and those have been dealt with in some detail by my learned friend. I would just mention that obviously various attempts to distill or summarise the principles of conforming construction have been made in various cases, and there's a summary at paragraph 58 of the Upper Tribunal's decision, which is at core bundle tab 4, page 59, and that refers to some of the statements made in earlier authorities in relation to the applicable principles. So what one sees there, without some of the internal citations that some of these summaries contain, that the obligation is broad and far-reaching, and there are various features of the approach, including permitting departure from the strict and literal application of the words and so forth. As we'll see in a moment, in some of these in some of these summaries, reference is made to what was said by the Chancellor in Vodafone 2 about two matters. One was the fact that, notwithstanding the submission I've made about roaming through the tax code, any provision within the UK legislation can be the subject of the conforming interpretation, not just the provision which in itself might be thought to give rise to the infringement of EU law. And secondly, as the Chancellor put it in Vodafone 2, that it's inevitable that the application of a conforming construction will have a retrospective effect. And he said in that regard that it's no more an objection in the field of conforming interpretation than it is in the case of domestic statutory construction. That's Vodafone at paragraph 56.
26.
56, forgive me.
56, thank you.
But in relation to the various summaries, including that at paragraph 58, it's important, we say, to keep in mind the context in which the various statements were made. And we would say that it is clear from some of the decisions of the House of Lords and the Supreme Court that, notwithstanding the apparent breadth of some of those statements of principle, there are limits beyond which the courts shouldn't stray. And we say that that's evident from Fleming, and then amongst other cases, FII, Supreme Court 1, and Routier, where it's been held that the courts have gone too far in seeking to apply a conforming construction. And in relation specifically to retrospectivity and the proposition that it's inevitable that the application of a conforming construction will have a retrospective effect and that it's no more an objection in the field of conforming interpretation than it is in the case of domestic statutory construction, we don't dispute that as a matter of general principle. But we would respectfully suggest that it must be subject to the important proviso that a court's ability to give legislation a conforming construction is subject to and limited by the principle of legal certainty. And I'd also observe, following on from that, that an interpretation which is arrived at by a so-called highly muscular approach to conforming interpretation is perhaps inherently far more likely to increase the risk of conflict with the principle of legal certainty than ordinary principles, domestic principles of legislative interpretation, for the very reason that the extent of the retrospective judicial rewriting of the provisions that may be involved. So, whilst on the face of it, the declaratory theory, which my Lord Justice Miles adverted to when my learned friend was making submissions, applies, and on the face of it, retrospectivity is no more an objection than in the case of domestic statutory construction. One can easily see that in circumstances where one is adopting a conforming instruction, which, as we submit, and I'll pick this up in the authorities probably tomorrow morning now, as we submit, the whole approach of conforming construction is limited by the principle of legal certainty. One can see there, as I say, that the risk of conflict. By way of
some interest, isn't it, that Vodafone, which is often taken as the most complete summary, albeit it's been added to, did come after Fleming, and indeed, I was just looking at it, referred to Fleming. And so the summary that was given in that case did take account of the approach of I think it was the House of Lords, wasn't it, in Fleming? Yeah.
My Lord, it was, yes. There are some points which I suspect I won't get onto today in relation to quite what was happening in Fleming, which I'll try to explain by reference to how the case had been approached in the Court of Appeal and the slightly different way in which it seems it was applied in the House of Lords, which may have a bearing on that. Before getting onto Fleming, or indeed not getting onto Fleming in any great detail, because my friend Mr. Johnson has done that quite fully, I was by way of quite deep background to the whole approach to conforming construction, just going to allude in passing to three decisions of the House of Lords, which are really the fons et origo of the relevant principles, which is Pixton and Freeman's, Litster and the Fourth Dry Dock, and Gaidan, which you've already heard something about. I'm not suggesting we need to go there now. So far as Pixton and Freeman's is concerned, the issue was whether a woman employed on like work with a man in the same employment, for the purposes of Section 1.2a of the Equal Pay Act, could nonetheless also rely on Section 2.1c, under which she claimed to perform work of equal value in terms of the demands made on her to that of a man in the same employment. What the House of Lords did was to imply the words "as between the woman and the man with whom she claims equality" into Section 1.2c, thereby making it clear that she could rely on Section 1.2c, even if she'd also been able to rely on Section 1.2a. I mention it because it was a relatively modest adjustment to the existing legislative wording, one which was clearly wholly consistent with the purpose and aim of the legislation in question, that being to give, so far as relevant, effect to the equal treatment principle under EU law and pay the way for the UK's accession. The same can be said in respect of Litster and Fourth Dry Dock. The relevant regulations, there are only protected workers who are employed, as it was put, immediately before the transfer of an undertaking. But the House of Lords read in additional words to protect workers, not only if they were employed literally immediately before, but also when they would have been so employed had they not been unfairly dismissed by reason of the relevant transfer. Again, we respectfully say that was a modest modification in keeping with the purpose of the UK provisions, which was similarly intended to implement EU provisions, in that case a directive, whose purpose was to protect the workers in an undertaking when its ownership was transferred. Gaidan, of course, was a Human Rights Act case, where a protected tenant died. Paragraph 2 of Schedule 1 to the Rent Act provided that a surviving spouse, including a person who was living with the original tenant as his or her wife or husband, succeeded as a statutory tenant. In the absence of a surviving spouse, another member of the original tenant's family who was residing with the tenant for 2 years was entitled to succeed as an assured tenant. In Fitzpatrick, the House of Lords had held that the survivor of a same-sex partnership didn't qualify as a surviving spouse, but did qualify as a member of the tenant's family, and so could succeed under paragraph 3 of Schedule 1, but not paragraph 2. The issue in Gaidan was whether that ruling survives the entry into force of the Human Rights Act. Their lordships concluded that limiting paragraph 2 to heterosexual couples violated Article 14 in conjunction with Article 8 of the Convention. The question arose whether Section 3 of the Human Rights Act required the court to depart from the interpretation of paragraph 2 in Fitzpatrick. Under Section 3, which is itself based on mar leasing, legislation has to be read and given effect to in a way which is compatible with convention rights so far as it's possible to do so. And the majority held that paragraph 2 was to be interpreted as extending to same-sex couples. Although that involved a departure from the language of the legislation, in substance it represented only a relatively modest extension of the provision, and one which was consistent with the underlying aims of the statute. Even there, however, as Lord Roger said at paragraph 121, that's at Authorities Bundle 3, behind tab 41, page 840. Between A and B, the top of page 840, the sentence beginning, if the court implies words. If the court implies words that are consistent with the scheme of the legislation but necessary to make it compatible with convention rights, simply performing the duty which Parliament has imposed on it and on others, it's reading the legislation in a way that draws out the full implications of its terms under the convention rights, and by its very nature and implication will go with the grain of the legislation. By contrast, using a convention right to read in words that are inconsistent with the scheme of the legislation or with its essential principles as disclosed by its provisions doesn't involve any form of interpretation, by implication or otherwise. It falls on the wrong side of the boundary between interpretation and amendment of the statute. And if one goes back to page 816 at the top of the page, In paragraph 49, the crucial point that Lord Steyn identified, as he put it, was there's sometimes been a tendency to approach the interpretative task under section 3.1 in too literal and technical a way, too much emphasis on linguistic features. But he went on to say, that is, of course, not to gainsay, this is just above B, not to gainsay the obvious proposition that inherent in the use of the word possible in section 3.1 is the idea that there's a Rubicon which courts may not cross. If it's not possible within the meaning of section 3 to read or give effect to legislation in a way which is compatible with convention rights, the only alternative is to exercise, where appropriate, the power to make a declaration of incompatibility. We say the situation in our case is to be distinguished from the Pixel and Litster and Guidam because there's no obligation to adopt a conforming construction to the legislation, and because what is proposed is something very different from a modest and incremental extension of the existing legislation. Would that be a convenient moment?
I think it would. Thank you. How are you doing?
Well, I'm not doing too badly, not least because quite a lot of the material that I otherwise have had to ask the court to consider, you've already been taken to. So I think I'm not sure if we're ahead of the timetable, although I'm mindful of the desirability of getting ahead of
I'm
it.
just
But we're definitely on
asking you whether you're on track. That's fine. And whether, therefore, you're happy to begin at 10:30, and it seems that you are. Thank you.
All right,